Good afternoon, everyone, and thank you for joining today's webinar. This is the fourth of our Witham and Genova Burns joint webinar series for the cannabis sector, Planting the Seed, How to Overcome the Financial, Legal, and Other Weeds to Become a Winner. Today's program will focus on what to know for the cannabis licensing and avoiding litigation. Our presenters are Charles Messina of Genova Burns and Tom Reck of Witham. Before we begin, I have a few notes. Today's materials can be found in the toolbar on the right of your screen. Also, at the bottom of the toolbar, you will see a questions box. Feel free to send us your questions during the presentation. We'll do our best to address them either during the session or afterwards. Once the webinar is over, there will be a pop-up asking you to complete a survey of today's webinar. Please take a moment to complete it. It is our way of being able to provide you with the best and most relevant programs possible. With that, I will turn it over to Charles.
Hi, everyone. As Rachel said, this is the last of our four-part series with Witham. So I'm not going to bore you kind of with stuff most of you probably know by now, like what is cannabis? Also I've lectured a lot, just myself personally, this past year, or several times at least, about cannabis licensing, and we'll get to that with a specific focus on New Jersey and New York at the end. But wanted to start up front with some basic litigation and business advice that I think is really important for the industry. So we can move the slide over maybe to the disclaimer so everyone sees that there. Just back up one. In terms of my background, after clerking for a trial judge in New Jersey, I joined the litigation department of one of the largest national firms, and now I've been a litigator at Genova Burns for 2012, almost 10 years. During that time, handled so much of the type of litigation that we're going to briefly talk about, and there are lessons to take away that are especially important to those seeking to enter the cannabis industry. So if we can go to the next slide, you'll see insurance is the first bullet here. And this is because no matter what you do to protect your business, you can't actually avoid getting sued. So the title is a little bit deceptive, I suppose. I defend businesses against people and companies filing frivolous litigation, for example, all the time. And when my clients call me or our firm to handle a case, can you guess what my first question is? It's actually not if you have insurance. I hope that all of you with businesses do. It's actually, let me see your insurance policy. And I say that because I actually don't trust a lot of brokers to advise clients correctly on coverage at this point of my career. I found that many brokers don't necessarily have specific industry knowledge to recommend adequate insurances for each line of business. So for example, in the construction industry, if you don't understand that industry and what coverage you need, or the hospitality industry, how are you going to correctly advise on certain coverages, right? And I think that clients oftentimes, place all of their trust to these sorts of professionals. And this could not be more critical in the cannabis industry because it's not just industry knowledge. It's also strategies on how to get coverage with very limited options. So as of today, and this is one of the things that all of you, I hope, know by now that are listening, I haven't seen the list of registrants, so maybe not, but marijuana remains a Schedule I drug under the Controlled Substances Act. Due to the Schedule I classification, any manufacturing, possession, sale, or use of marijuana is technically a federal crime. We won't get into the Cole Memorandum and the Obama administration and the lack of sort of enforcement in that regard. But due to the 2018 Farm Bill, the production and use of hemp and its derivatives, including CBD, present far less complications with respect to insurance. Although ask some CBD operators, and you'll find even for that industry, it's very difficult. Now, the Farm Bill effectively decriminalized the production and use of hemp and cannabis derivatives with lower than a 0.3% THC concentration on a dry weight basis. So again, easier in that industry. Some examples of coverage options that you should implore to get would be D&O, directors and officers liability coverage, commercial property insurance, employment practices liability, product liability insurance, workers' comp, commercial general liability, automobile insurance if your delivery company have drivers or employees that drive. In New Jersey, at least, Senator Menendez has recently introduced separate legislation allowing legal cannabis operations to buy insurance just like any other business. We'll keep an eye on that. But because insurance options are typically very limited, even when you get it, with myriads of exclusions and expensive, some cannabis companies are actually opting for something called captive insurance. So I could talk for a while on this. I know we're limited in time here. I mean, in general, captive insurance is a form of self-insurance. It's typically formed by one or more several parent companies. You could link up with a program. We have Bill Megna as part of our firm. You know, this is sort of a niche area. He's been doing it his whole career, forming captives, and he is really the guy to talk to about captives. And I'll just end with this: choose your insurance professional wisely. You know, kind of like with all these other professionals. So the next slide here, we have trademarking. I'm sorry, go back to the same slide. I'm at the second column of our slide, trademarking and trademark infringement claims. So in branding is an expensive part of starting a new company just generally. And navigating that trademark process to protect the brand can be difficult for any business. In the cannabis and CBD industry, however, I mean, these kinds of businesses in this industry, you face additional hurdles considering the USPTO, that's the United States Patent and Trademark Office's overall position on cannabis-related trademarks. So starting with CBD, since hemp-derived CBD is federally legal, you can register for federal trademarks. And there have been a flood of applications over the past few years since the Farm Bill was enacted in 2018, in December 2018, to register these CBD kinds of businesses and in CBD-infused products. But it needs to be carefully done. The application, among other things, and our firm does this regularly for CBD companies that retain us to do it, you have to specify that the products, for example, contain less than 0.3% THC. If the products are going to be used or sold in connection with kind of the same brand for cannabis or Delta-9 THC, other beyond 0.3% THC products or base services, and not just for hemp and CBD products, that's going to be a reason why you're not going to get a trademark potentially. And state registration should be considered. So each state has its own requirements. It's not something typically really ever done in other industries, right? It only confers generally the benefits of registration within the boundaries of that state, assuming cannabis is legal in that state. But just in terms of trademarking generally, we're talking about CBD, for example, the first most important thing to do is to check for blocking marks. So that's the first step in the trademark application process. You have to perform a thorough search to determine whether that mark, whether it's your name mark or the logo, is being used by other companies in the industry. And then evaluate the probability that your application will not be deemed to cause consumer confusion, because that's ultimately one of the standards, right? Is my mark, if it's infringing on another company, would it cause consumer confusion? And that's a test in order to get approved by the USPTO. So when you file your application, you're assigned a trademark examiner. But again, before doing that, check for blocking marks. So what does a comprehensive search mean? I mean, folks and clients that come through our door sometimes think, well, I did a thorough Google search. I see nothing on the internet. I'm okay, right? Or I could change a letter, even if there's a company like mine, but my spelling is different, I should be okay, right? No, so the answer is no. If you don't perform an adequate search, it's called a test search on the USPTO website, you run the risk of finding out months and even years later that there's already a trademark registration that exists for that exact same mark. So important to take that first step, rather than finding out maybe months or years later by a cease and desist letter or a lawsuit for trademark infringement, that you didn't kind of get it right in the beginning. And obviously, the cost of defending these types of lawsuits, which I've handled since the beginning of my career, can be very costly with experts and the like. So in terms of the cannabis industry with trademarking specifically, I mean, it's just become familiar where, you have well-known companies alleging trademark violations by startup brands. So just recently, you have the owner of a tobacco giant, Kool Menthol Cigarettes, spelled K-O-O-L. They filed a lawsuit against a company called Bloom Brands, which is more or less a startup cannabis company, for trademark infringement. So Kool, I don't have it on the slide here. Let's see if I can just write it. So they allege that Bloom's logo, specifically the interlocking O's in Bloom, infringes on its well-known trademark. Let me just write it out here for a second so I can show you on the screen. Let's just show you Bloom and Kool, okay? So The Cool lawsuit represents an even more important lesson, I think, evidencing how, like anything, even interlocking letters can be considered a trademark by the company using it. And so right now that lawsuit hasn't, we don't know if it's going to be successful, but Bloom Brands is going to be saddled with attorney's fees and potential irreparable damage to its brand. So, every company, I think, the bottom line is you want to strive to prevent this kind of lawsuit. It can usually be accomplished by performing a thorough trademark search in the beginning. The second component of trademark infringement and kind of avoiding these types of claims is the specimen you're using when you're submitting your trademark, establishing use, right? To do this, you have to submit something called, again, a specimen. A specimen is anything that shows your mark being lawfully used in the marketplace, such as images of your product packaging, advertisements, business cards, even a screenshot from your website would suffice. Now, that seems like an easy task. I mean, you could encounter difficulties there. There's a recent cannabis lawsuit. To give you an example, Carrick Harvest, doing business as Veritas, Fine Cannabis. Their competitor, Carrick, sells cannabis-related products under stylized V trademark. Carrick applied to register its services under informational services. So cannabis company registering for informational services. They say the services on their website provided information about products. So that's what there's over 200 different kinds of classes that you can apply for. So that's the informational services class they chose to apply for their trademark in. But for the specimen, they submitted screenshots from the website containing cannabis-related news and information. Now, a judge found these images were purely promotional because they only discuss Carrick's marijuana-related goods. Those goods are not protectable under federal law. So they're not getting that trademark. Now, something like this, you can get around it, can be protected. And you can allege, or rather you can file for informational services related to cannabis products properly. The USPTO, in fact, they've approved a number of these trademark applications for these types of services in the case where the applicant established that there wasn't a fact of service being provided. So bottom line here, kind of similar to insurance, you want to link with a professional or educate yourself kind of thoroughly that knows what they're doing to get it right from the beginning, because your branding is an important part of your business in this space, like others. So next up on this slide, Telephone Consumer Protection Act, TCPA, another type of litigation that I've personally handled and is now really impacting the cannabis industry. So just marketing in general, I think, with all industries has taken a pivot towards more direct methods of communications as a result of COVID-19. So specifically telephone calls and text messages, they've ramped up. They've become critical connecting points between companies and consumers. And again, really true for the cannabis and CBD companies. Just think about all the significant restrictions already marketing online and in general. Now, the types of lawsuits you hear about are when you have companies promoting online or otherwise that their product cures cancer and claims related to health. So now there's been an onslaught of claims over this past year alleging that these types of companies are harassing consumers with spam text messages in violation of something called the Telephone Consumer Protection Act, TCPA is called. So it was enacted in 1991 to address the growing number of robocalls. An important amendment is that companies that do this type of telemarketing have and maintain company-specific do not call lists. The lists are meant to ensure that once a customer opts out of the communications, they're no longer contacted. Some other amendments that are important, if you're going to do telemarketing with your business or have a company that does marketing, I would say, by the way, in that contract, not that this is a cure-all, but you want to make sure in that contract with your marketing company, they're not going to violate the TCPA and abide by all federal laws, get an indemnification provision. But the company telemarketing making these types of calls with auto dialer equipment, they have to obtain prior express written consent from the consumers before robocalling them. You can't rely on something that was considered an established business relationship exemption for pre-recorded marketing calls to residential numbers. And you have to give consumers an automated interactive opt-out, press 1 to not receive these calls anymore. So it's significant. Non-compliance with the TCPA can lead to fines of up to $500 for unsolicited text message, fax, or call. That's if the consumer faces no harm. If they just get that call, it's violative, $500 a pop, and up to $1,500 for each willful or intentional violation. So, the most problematic thing is you have one victim that gets this call. They file it as a class action on behalf of every consumer that received a similar call. So one call you make, just one, that could cost $500 could result in millions of dollars of liability. So these lawsuits, especially class actions, they're very costly to defend against at times. Just one example with a cannabis company, Jackson versus Euphoria Wellness. It's just, again, a similar theme, right? A class action filed in federal court in 2020 against a cannabis company alleging that this particular dispensary sent text messages to members of a class who were on the National Do Not Call registry, and they used automatic telephone dialer equipment to market their products. So bottom line here is that, like, maybe some of the professionals that are listening here trying to cash in on the green rush, unquestionably, serial TCPA plaintiffs and their attorneys are doing the same. So before your company launches that next text message campaign to promote your brand, make sure you're up to date on these regulations. Finally, and I'll just talk briefly here and then pass the mic to Tom, so to speak. Set up your business correctly. We had, I think, our second of 4 webinars. We had Keith Krause, who leads our business department, talk about this. Tom's going to talk a little bit about it. I've handled so many different types of partner disputes and litigation related to owners of our company suing other owners. It's everything from, he made a pass at my wife and I'm going to knock him out if I ever see him again, to a partner getting sick and dying, or just business disputes. So one thing is trust, right? You need to trust your partners. You really want to know them. It's a metric that's never going to change. From a legal counseling perspective in this industry, if your partner's promising that they have something, like, I have property locked up, I have, I'm going to get a letter of support in terms of licensing from a town, that stuff can blow up in the last second. You want to verify it. As a lawyer, I always advise, unless it's like your brother, and even sometimes then, close friend, get a background check. Memorialize your understanding in writing. That's a big thing, right? If you're forming an LLC, what's the percentage of ownership? What's the division of profit and loss? How do I get out if a partner wants to get out? And what happens if you need capital? So a major thing, I know, like Keith in our department, and we always advise clients, don't give equity unless you have to. And definitely don't give it right away in exchange for services over time. That's a mistake I think a lot of young companies make. They don't have money in connection with the company to offer, so they want to offer equity. But if all this other potential partner wants is money in exchange for services, you can give them economic rights and accomplish that by a separate contract without full membership rights. So with that, I'm going to pass it to Tom, and we'll come back to licensing if we have time at the end.
Fantastic. Thank you, Charles. Oh, you're already on the next slide. Thank you. So at the outset, everybody gets along, right? I mean, everybody is thinking about this new venture that lays in front of them, and they're excited about what the future holds. And at that point in time, it's difficult oftentimes, and I'm sure Charles will agree with me on this, it's difficult to get folks to think about the day when the picture may not be so rosy. And people will try to downplay the possibility that there could be problems later on down the road. Oh, Charles and I had never fight. We've been friends since 5th grade. You hear this sort of thing, and inevitably, to a certain extent, that does not hold to be the case. So remember from the outset, as Charles was saying, one of the things you want to do is limit your liability. What are the debts that are going to remain with the or keep the debts so they remain with the company and not on you personally? That's the first thing you're looking to do. And then the second is, consideration as to the tax treatment. If you're going to be bringing folks on board, you don't want them to be in a situation where, let's say at the end of the year, they're getting a K-1 and they're saying, what in heaven's name is this? And what does that mean? And, what effect does this have on me? And there's a surprise. So you need to think about what the structure of the entity is going to be at the outset. Maybe you're going to have a limited partnership set up where, the person who's running the business, so to speak, is the general partner. The limited partners will basically be passive investors and won't have any responsibility for the debts, for example. So that's consideration. Sole proprietorships. Look, some businesses, some folks like to keep things close to the vest. If you do something like that, I would strongly suggest, as Charles was discussing insurance, that you make sure that you are well insured for anything that might happen. The last thing you want to have is somebody suing you personally as a result of your sole proprietorship, saying that they got sick on a gummy that you sold them 3 weeks ago. So that's something to also keep in mind, remembering that the whole premise that we're talking about today is avoiding litigation. Next slide, please. Okay, so when we're talking about corporations, there's basically two types of corporations. You have your profit, your not-for-profit. There is something called a benefit corporation. So a benefit corporation essentially lays out that the corporation is going to do things that will positively impact the society in which they operate. That is an option that is available to people, and that's been around for, I don't know, probably the last 10, 11 years. So that is something to consider. Now, in terms of structure, there's a couple of different options to you, right? You could have the straight corporation, and you would have the ability then to go either C corporation or S corporation. If you're a C corporation, you potentially run the risk of double taxation. So remember that if it's a C corporation and there's a profit, then the company was going to get taxed on the profit, and then when either the profits are forwarded to the owners, there's going to be a second level of tax at the personal level. So that is something to consider. The next thing would be to be a corporation, but to be an LLC, for example. So as a matter of fact, if you go to the next slide, I believe that is, yep. If you set yourself up as an LLC, you're essentially protecting yourself in terms of how the liabilities are going to be distributed at the end of the day. Now, the characteristics of an LLC are such that each person that's an owner is technically called a member. So there'll be an operating agreement or limited liability agreement, and that's going to provide you with the structure of the entity, whether, who's going to be managing, who's going to be the limited partnerships, etc. So that is something to consider. You also have the ability to, as we said, be a C Corp, an S Corp, or a disregarded entity if you have only one member, and then it would still flow through to you individually, but you would be an LLC. So it would appear on your tax return as if you were filing a Schedule C, for example, but you'd be a single member LLC. Next slide. Okay. If you are looking to grow the business, meaning that you think you're going to be looking for outside individuals or companies to invest into your business, you may want to give consideration to being a corporation. That's a structure that most entities, most investors, I should say, are familiar with. They know exactly what's at play. So that would be something you would look to consider. The downside to it is a lot of times if there's a number of agreements that are in place, the larger investors don't necessarily want to be reading and analyzing the operating agreements. But if your role is to grow the business, any profitability is going to be reinvested back into the business, or there may not be that much profitability as you continue to grow the business and you're looking to take on new investors, corporations would be something that you would want to consider. LLCs, a nice thing about LLCs is you have tax-free distribution to the extent that there's basis. So if you have a profit that can be distributed, it's not being reinvested. When there is money available to be distributed and you have basis in it, you're getting that money back tax-free. You've already been taxed at the income when it was initially earned. So remember, that's the difference now that we're talking about between the double taxation at the corporate level and the flow through income at the LLC level. And as we were discussing a second ago, you can choose how to be taxed. So if you want to be an S corp but an LLC, you can do that. That's certainly something that that's beneficial to you. Next slide. Okay. At the outset, some of the things that you're going to want to do is really lay out who is responsible for what. So you're going to want to deal with what the governance is and what the right to participate in running the business is. So for example, let's just say Charles and I were to become involved in a business and I'm looking to essentially run the business, but I really don't want Charles's involvement. The only thing I really need Charles for is a $500,000 initial investment, let's say. That needs to be laid out, because the last thing you want is for you, the person who you think has the autonomy to run a business, being sued either by Charles or through some sort of derivative action through one of the other members, basically saying, hey, wait a minute, you know, the corporation would be better served if Tom had done this. So you don't want to be in a position where it's unclear as to what the line of demarcation is in terms of who's doing what. That's extremely important. The other is, what is the amount of money, what's the economic benefit to the person who's investing? You know, as Charles was saying a minute ago, you know, don't give equity if you don't have to. If you're close to the goal line, if you're on the 5-yard line and all you need is, I'm going to make up a number, a $500,000 loan to get you across the goal line, then get a loan. Don't give equity. There's no reason to do that. But if for some reason you do give equity, you have to be quite clear as to, you know, what it is they're getting. How are profits going to be distributed? How is capital going to be shared? They're not necessarily the same. So that's something to give consideration to. You know, what happens upon liquidation? So for example, let's just say the business goes belly up and there's obligations that are owed by the entity. What's the obligation of the person that invested, I don't know, $200,000 5 years ago, let's say, and you know they really haven't thought much about it subsequently. Now they get a letter saying that, you know, they need to kick in an additional $500,000 because the company went belly up. That's something that needs to be considered. So, you know, what are the rights upon liquidation? Let's go to the next slide, and we'll talk a little bit more about this. So, let's talk about funding, right? I think it's very important, and I'm going to circle back to it. The premise of this is avoiding litigation. Don't underestimate the amount of money that you need to get the business up and running. You really need to take a step back and understand what's involved. So initially, you know, you're going to have any fees that are going to be need to be paid. You're going to have to hire attorneys. You're going to have to hire consultants. You're going to have to go through the whole application process, which is not cheap. And let's just say, you know, you want to set up a little shop somewhere. Okay, what's entailed with that? You're going to need to figure out how many square feet you need, what the initial rent security deposit is going to be, what the lease terms are, and you're not going to want to, or hopefully you're not going to want to commit to something before you know you've been approved. So you're going to need to be very carefully thinking about, okay, assuming I get approved for my license, what do I need? So now I've got this initial shell of a building. What next? There's going to be build out costs that are required of you. There's going to be cases that need to be put in place. There's just a lot of money, especially early on, that I think a lot of people don't necessarily think about. And I don't mean this to scare anybody, but I really want them thinking critically about what it is they're looking to accomplish. And as I said, there's a lot of money that's going to be needed, especially up front. When you're thinking about, bringing on additional investors, as we discussed, what are they looking to get moving forward? Always think about them now in terms of, if I do this, then that. That's the basic premise by which you want to work by. And if you have someone that is on board with you, let's say they're working the day-to-day operations, you may want some sort of non-compete agreement from them. You may want something in place where they just can't leave your shop and take with them some of your trade secrets now. So that's something to be considered as well. Next slide. Okay, additional items for consideration. As we talked about, a clear understanding of the roles to be played is necessary. If you think you're bringing someone in as an investor and that's all they're doing, that's fine, but both parties need to be aware of that. Compensation needs to be discussed. So let's just say Charles and I invest in a business, and Charles has his hard-earned money in the business, and I'm working at the business, Charles is not. How long is it going to be before I start to resent my friend Charles, who I've known since the 5th grade, because I'm going to the business every day and I'm working. I'm actually dealing with the folks in town. I'm having everything built out. I'm having the telephone calls and the meetings with the suppliers. I'm talking to the guy that's going to put the sign up in the front of the store, whatever it is. I'm going to want to be compensated for my day in, day out, the day in, day out work that I'm performing. So there needs to be an understanding as to what that compensation is, how it's going to be determined. Now, if you have someone who brings with them a certain set of skills, you may want to lock them in. So let's just say, they're good at developing certain combinations of chemicals within the cannabis itself, making it stronger, making it not as strong, whatever the case may be. You may want to lock them into some sort of agreement so that they're working with you for a period of time. They know that they're going to be compensated a set dollar amount for a period of time, and they can't divulge any of the secrets, if you will, that should be inuring to the company. Because remember now, they're working for the company. You want to make sure that you've locked them in. There needs to be an agreement in terms of certain life events that I think we skipped ahead a slide. There needs to be certain life events that need to be discussed. So, for example, Charles and I are both owners of a business. Unfortunately, in a week from now, I have an automobile accident. I am disabled. I can no longer work at the business. What happens? I die. I'm hit by a bus and I die. What happens to my estate at that point? I've got $3 million invested in this business. What happens? So that all needs to be discussed. And that's the sort of thing that also dovetails very nicely with the idea of insurance. There needs to be insurances in place that think about events like this happening. Now you'll notice there's something missing here in terms of life events that you would normally see, and that's bankruptcy. There is no bankruptcy at the federal level, given that this is a cannabis business. So again, that's another consideration when you are trying to avoid litigation down the road. Next slide. Okay. You'll often see that there needs to be a clear definition of what constitutes value. So what do I mean by that? Let's say Charles and I were both relatively unsophisticated, for lack of a better way of putting it. We download some agreement off of, Google or whatever, and we both sign it and we think that we've got ourselves protected. We know what's going to happen. And let's just say included in that agreement that we've now both signed and we think is foolproof is the term fair market value. And Charles is an 80% owner and I'm a 20% owner. And let's just, let's play this through. And we end up in a lawsuit at a certain point in time. And let's just say, for purposes of this discussion, we value someone to assess the value of the business, and they say that the value is, I don't know, $1 million. So I'm entitled to, you would think, $200,000. Charles says, no, 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 no. You're not due $200,000. You're due only $150,000. And I say, but Charles, why would that be? And he says, because when we signed that original agreement, it said fair market value. And in fair market value, there are discounts. And you only have a 20% ownership interest. Therefore, it's not a pro rata share, my friend. I'm screwing you out of the $50,000 difference, the 150 versus the 200 that you think you're entitled to. So you need to be very cognizant of what you are signing. If there's language contained in a document, please make sure that you understand what that language means. Sometimes you'll see in documents there will be something, a formulaic driven metric, right? So it'll say the value is to be 50% of gross revenue, or the average gross revenue over the last 3 years, or 5 times EBITDA, or whatever that equates to. You know, you will see that from time to time. I will tell you that more often than not, it's not going to give you a good value. There are just too many variables involved in a business where that particular sort of formulaic approach works. There may be some, I have seen it from time to time, where, you know, it kind of makes sense, and sometimes there's no real easy way to explain it other than it does make sense if you actually went through the mechanisms of trying to value a business and then use the formulas that come here. You'll come in with a very similar result, but more often than not, that is not going to be the case. You might want to consider in an agreement language to consider some sort of what they'll call an annual certificate of value or certificate of value. It doesn't have to be annual. Sometimes it can be every 2 years, every 3 years, depending. But basically what you would do in a situation like that is you would have an outside appraiser value the company, and in the event that something happens, there would be a lawsuit. I will tell you that that's a great idea. The problem I find is, you know, you have people that have been involved in business for, you know, 20, 30 years, and the last time they had that calculation done was probably 20 years ago when they first started the business. So, you know, that is something that needs to be discussed. And if you can do it, I think it's a great way to do it.
Tom, just to quickly jump in on that too,
Sure.
because and Tom's bringing up a number of good things, and just so valuing the business is extremely important, especially if you get bought out or a partner wants to leave. These are some of the options. There are a number of options, and I've litigated them. I mean, some ways in terms of putting in your agreement, just as another option to throw out there. Each side could get its own appraiser in the event of a litigation or the event of evaluating the company. So again, you could really structure this however you want. Just to give you one example, one appraiser can come up with, you know, let's say it's me and Tom that are partners together. We could each have our own appraisers. You could have a metric where if our individual appraisers are within like $100,000, and you could set a metric of a difference, then the price of the business is going to be split in the middle. If we're above $100,000, then those two appraisers get a neutral third appraiser, and that is the one that determines the value. But these things are important, and often they're litigated because they're not really clearly set forth in an agreement, and that's where we get into trouble, when there's ambiguity.
Yeah,
Unless you
you're
purposely
absolutely
want ambiguity, but yeah.
Yeah, you're absolutely right. And you know, clearly, just given my background, this is something I see all the time. It's something that I would feel if I didn't discuss it today, I'd be doing folks a disservice, because you really do need to be giving consideration to the structure of the business itself, what the expectations are in terms of funding a business, what the expectations are of actually working a business, what the expectations are in terms of a return on that investment, what the expectations are if and when there's an event that causes you to no longer want to be or be an owner of the business. And, you know, those are all the sorts of things, the trajectory of a business from its inception to its completion. And with that, I will throw it back to you, Charles. I hope I didn't run too long, Charles.
Unmuting myself. No, I'd rather hear from you than myself. Great. So I guess let's go to sort of the licensing end of the presentation. So I assume most of you know that cannabis has been voted in November. To give you a quick lay of the land, I mean, you hear about now the 17th dispensary, I think, which just opened. So 17 dispensaries in New Jersey on the medical front, but still only 12 licenses. That's 12 vertically integrated licenses. ATCs are called alternative treatment centers. Vertical integration means that these companies with these licenses can cultivate, meaning grow their own cannabis. They could dispense or sell to the public, to just medical patients right now. And then third, they could process. So prior to Governor Murphy taking office in January 2018 in New Jersey, there were only 6 ATCs awarded these vertically integrated licenses, so 6 prior to him becoming governor. There was another medical round for licensure in July 2018. 6 vertically integrated licenses were awarded and a request for admission. There was 148 applicants and 6 additional, bringing the total to 12, 2 in each region of the state, north, central, south. In July 2019, I'm sure many of you probably know this, there was 24 total additional licenses, and that application process ended quite a while ago, but it was held up in litigation. Among the 24, there will or should be 5 cultivation licenses awarded, 15 standalone dispensing and other verticals. So that round again was stayed based on a lawsuit. Long story short, because our time is short, that stay was lifted. I think the 24 licenses will be awarded very soon. I keep saying that, hasn't happened yet. We can go to, we'll stick on this slide. So the referendum passed. We have this bill that was enacted, legislation called the New Jersey Cannabis Regulatory and Expungement Aid Modernization Act. It's a mouthful. I'm going to call it CREAM because I think it's funny and catchy, even though our legislature probably doesn't want it to stick. It's a comprehensive bill, 240 plus pages. It's expected to be a model for other states. We can go to the next slide. So now we have the Cannabis Regulatory Commission. It's completely filled out. The CRC has the authority to, among other things, adopt, amend, repeal regulations that control the cannabis marketplace. It could also revoke, cancel, refuse, or take actions otherwise limiting licenses or conditional cannabis licenses. Again, all the members have been named. You see it on the screen right here. Jeff Brown, the Assistant Commissioner of the Department of Health, who was leading the medicinal marijuana program in New Jersey and still does. He's tapped to become that first executive director of the CRC. We've had 3 meetings already. First meeting April 12th, as you see on the screen. We can go to the next slide. And we'll get to PA and New York at the end here. What time are we at? 12:45. Okay. So in terms of decriminalization, other aspects of the bill, as you can see on the slide, it decriminalizes possession and use. And you could read the rest of the bullets here. You have to purchase it directly from a New Jersey licensee. You can't smoke in public, which is different than New York's law. New York's law is different in many ways, actually. We can go to the next slide. You can't drive under the influence, as you can see here. Smell is no longer a probable cause. Next slide. And you could look at what's decriminalized here. Simple possession of marijuana as a motor vehicle operator, etc. Next slide. And there will be 6 main types of licenses to apply for. Just really quickly, cultivator, we spoke about, permits growing, cultivation. Class 2 manufacturer permits the manufacturing, preparing, or packaging of cannabis. Wholesaler permits the storage and sale of cannabis strictly for resale. Distributor permits intrastate transportation of cannabis in bulk, intra meaning just within the state. Cannabis is still illegal at the federal level, so we can't transport it over state lines. Class 5 retailer, that's your dispensary. It's the only license right now, unless something changes, where retailers can also operate a cannabis consumption area for the public. I'm sure we'll get more meat on the bone from our CRC on that soon. Certainly by August 21st, 22nd, when they have to basically be done with this. And at that time also, we had a great, the third of our fourth installment of this, we had Jen Mazaway from our real estate department present on all the real estate considerations. And one thing, as I'm sure all of you that are following the news in New Jersey is seeing, is that certain towns, they have until August 21st to opt out or not in terms of permitting cannabis businesses within their borders. No town can prohibit delivery sales into their towns. So there's a lot of decisions being made by towns right now. Also needs to be done by that deadline in terms of opting out or not. And then Class 6 is your delivery license, permits delivery cannabis from a retailer to the public. Yeah, as currently written, there are certain restrictions with respect to holding two classes of licenses concurrently. So to give you an example, a grower or processor may only concurrently hold two licenses, either another grower or processor license for now. We'll go to the next one. So I want to try to get to questions if we can. So micro business license, definitely a number of advantages. At least 25% of the total number of licenses in each class are going to be reserved solely for micro businesses. The CRC can adjust the point system or utilize a separate point system and rankings with respect to applications for micro businesses. The maximum fee assessed by the CRC for the issuance or renewal of a micro business license, it can't be more than half the fee for your traditional license. So for example, to apply, which our firm helped teams in the last two medicinal rounds in New Jersey, in the 2018-2019 rounds, the price of the application was $20,000. If you did not get a license, you got $18,000 back. So let's say, for example, that's the same price, just the application fee as an example of one fee. The price for a micro business to apply should be $10,000. A lot more to talk about in micro businesses. One other thing that's really important is that as a micro business, as it stands right now, you can only apply as a micro business in a town in which you reside or in a town that physically abuts that town in which you reside, or the majority of your team members, with the limit to 10 are residents in. We'll go to the next slide. Which should be Pennsylvania. Yes, I'm going to limit it to one slide. There's not a lot to say at this point about Pennsylvania's adult use market because there is none. I had some clients and a friend attend the PA Cannabis Festival a few weeks ago. Apparently, with the number of vendors present and people there outside, it was pretty incredible. And you've heard Governor Wolf state several times, he wants Pennsylvania to get that tax revenue from the plant, especially following COVID. But if you look at New Jersey and now New York, a driving force behind adult use legalization has really been social justice and social equity. You had the Black Caucus here in New Jersey hold up the bill, to advocate for more enhanced social equity tax, which was great. And in Pennsylvania, you have a conservative state. According to NORML, Black people make up 12% of the state's population, yet they represented 32% of the arrests in 2020. So, based on cannabis. So it's those type of statistics you'd expect some rallying around, and there has been, just without enough legislative support. So we'll kind of move from a downer for those advocating on the adult use side of things in PA to, let's go to the next slide. The Big Apple, which I think more and more New Yorkers are going to start spreading peanut butter on top of now. Seriously, I've been following this race between New Jersey and New York especially. I think this got done so quickly because of the sexual harassment allegations against Governor Cuomo. Now this adult use cannabis industry, it's going to blaze forward. It's taken a lot of headlines like that away from the allegations against Cuomo. With his signature, it's known as this bill, it's known as the Marijuana, as you can see here, Regulation and Taxation Act. It was passed. In addition to regulating adult use of cannabis, it also amends the state's existing medical use law, the New York Compassionate Care Act. And it's not talked about a lot, but it also provides, among other things, robust rules for hemp, CBD, and other cannabis extracts. We're not going to get into that today because we're limited with time. We'll go to the next slide. We'll skip this, actually, go to the next slide. So in terms of what MRTA, I'll call it the acronym, means for New Yorkers, adults can personally possess up to 3 ounces of plant cannabis and 24 grams of concentrated cannabis without being prosecuted or arrested. In addition to decriminalization, the law also expunges convictions based on conduct, which is now authorized under MRTA. So unlike New Jersey's recently approved cannabis legislation, consumption of cannabis will be permitted in the same or similar places as vaping and cigarettes. I'm sure you've all heard that on the news. Also, New Yorkers will be able to grow their own cannabis. This is something, there's been a lot of advocates. Senator Vin Gopal introduced New Jersey, a home grow bill recently. Home grow in New York is going to be, it's not part of New Jersey's legislation now, home grow. It's going to be delayed in New York for months until more rules are promulgated and until retail sales commence. But once that happens, a household is going to be able to grow a maximum of up to 12 plants. That's 6 mature, 6 immature, with a 5-pound possession limit for adults. Throughout MRTA, there's really a heavy focus on social and economic equity. I'd say more than New Jersey, even, and this is integrated in the application process, the apportionment of tax revenue, and adjustments made to the penal code. Certain applicants can qualify as a social and economic equity applicant to help the Office of Cannabis Management get to that goal of reaching 50% of licenses being awarded to minority or woman-owned business enterprises, as well as distressed farmers or service disabled veterans. So we'll go to the next slide, and let's see what it is. So we'll skip Office of Cannabis Management. So these are the types of licenses you can see here that will be available. Because much of the regulatory licensing framework, it just doesn't exist yet. There's no established start date. You have reports suggesting sales could commence as early as December 2022. It's kind of a guess right now. Home growers for recreational use, or adult use rather, must wait no less than 18 months after the initial retail sales to plant their seeds. The tiered licensing structure, it actually prohibits those upstream in the production process from selling to the general public. You can see the available licenses on the screen right here. We can go to the next slide. Oh, there is no next slide. So we have 6 minutes left. I got some questions. Maybe I can start, Tom, if you want to jump back on social equity and how cannabis is taxed in New York. I know at least I've lectured a lot on how cannabis is being taxed in New Jersey. So in New York, MRTA places a tax on cannabis. It does it based on the amount of THC, or that's the chemical compound that delivers the effects of getting high to users. There will be a 9% state tax at the retail level. That bill mandates that about 40% of the estimated 350 million, I think is the projection, tax revenues. That's going to go to community grants and reinvestment. 20% out of the 100 is supposed to go to drug treatment and education under MRTA. 40% is earmarked for schools right now. There's also going to be a local excise tax of 4% in New York on the retail price. That's different. So New Jersey, 2% will go directly to municipalities in New Jersey. So again, back to New York, 4% of the retail price taxed. Counties are supposed to receive 25% of that 4% local retail tax. And then 75% of the 4% is going to go to the municipality. Sort of similar to New Jersey, but different. Municipalities can enact legislation to opt out of permitting retail dispensaries or on-site consumption lounges within its borders. Tom, any questions you want to tackle? Let me look at
Well, I see there's actually a question here, and I don't know the answer to it. I'm hoping maybe you do. The question is there a resource that exists to see who has applied for what, as well as existing licenses? Is that maintained anywhere at the state level?
I know I haven't checked in a while. Department of Health website, you can see what companies have applied for licenses. One thing you don't need a lawyer to do, although we will prepare it neatly for clients if they need it, is you can actually get portions, assuming you're interested in licensing, you can extract portions of applications that have been filed by successful applicants, for example, in New Jersey. Now, a lot of it is redacted, as you can imagine, but that's a really useful resource just so you can see, what is an experienced portion of another applicant that filed in New Jersey look like. So there's a lot of publicly available information like that.
And is there a list of towns, do you know, Charles, that are cannabis friendly? Do you know?
Yeah, we get this question so much. So
I get it all the time too, which is why I'm throwing it out there. Yes.
we are following it. I mean, like there's email chain between our cannabis group, which is now about like 7 people, where we were just we have our own list right now. But so there was a list of, I'm sure a lot of people know, the 70 towns that enacted some form of opting out or prohibiting cannabis prior to the bill being passed. There's a reset now, so that doesn't matter. And a number of towns have opted out right now. Certain towns are opting out just to opt out and see what other towns are doing, and they'll opt back in. Certain towns are just prohibiting or going to prohibit, it seems like, just retail licenses in their town, but they'll permit other types of businesses. So to answer your question, I mean, we have a list, we keep an ongoing list. There's a lot of good local resources out there that follow these things. There's companies that come up with lists. So, I mean, we're just tracking it for our own knowledge for our clients, but I don't think there's any like resource on the internet. If there is and anyone knows, let me know.
Right.
It's happening in real time though. There's meetings that are occurring every week or month, whenever these towns meet, figuring it out.
Yeah, and if anyone has any questions, please reach out, give us a shout.
At least on my view, I can't see any questions over here. There's one.
There are a few actually on insurance, but I think they're kind of, we need to circle back around with that individual from what I'm seeing.
Yeah, I see that, but that's the one that appears here.
Yep.
So I hope everyone enjoyed this. Thanks for the opportunity, for us to present to you. If you have any questions, I mean, Witham has been great to work with. Definitely trust them on the tax side of things and beyond. And it's important, I think, to get a CPA just involved in the structuring of your business process as well. That's it for us.
And Charles, you guys have been great. And you're, folks, it's interesting. There's you're going to see a lot of people getting involved in the space now. But, please remember who the persons were, who the parties were, and the companies were that have been at this from the outset. And that clearly includes Charles and Genova Burns. So thank you for your time, Charles. I appreciate your time today.
Likewise. Thank you, everyone.
Thank you.